Good morning, Your Honors. My name is Cliff Greenberg. I'm a Deputy City Attorney with the City of San Jose, representing the defendants in this case and appellants on the issues involved. This is a police shooting case, and it involves important issues of qualified immunity. The ultimate primary issue is, what does a trial court do, or what should a trial court do, when there are material disputed facts regarding the qualified immunity issue? Let me put that issue in perspective with the facts, if I may. On January 3rd, 2014, Officer Dondi West shot plaintiff Hung Lam after a report to the police of an incident with a man with a knife. As the court knows, there are essentially two distinct scenarios. The police officers explained and testified that upon arrival, Mr. Lam moved some. He moved to a driveway and then down the driveway, and ultimately moved toward Officer West in an unusual manner, admittedly, but toward Officer West with a knife in his hand. She retreated about 20 feet, issuing commands to stop and drop the knife. And when he got to about 10 feet away from her, she backed up into an impediment, felt she couldn't move any further, and when he still continued toward her, she shot him. As the court also knows, there was a witness, and the witness has a completely different explanation, recollection of the event. And that was that as soon as the officer got to the property line, issued a couple of commands, plaintiff Lam turned around to face away from the officer, made some motions with his hand with a knife toward his stomach, and the officer shot him in the back for essentially no reason. He was not threatening her, he was not facing her, he was not saying anything, he was not coming toward her. So those are the two separate scenarios.
We understand those, and I hope that you're not going to go too far into that, because the bottom line is your questions are about special interrogatories.
Correct.
Okay, so let's just go to special interrogatories. Is there a case which says that the refusal to give the special interrogatories is an abuse of discretion?
I haven't seen one.
Neither did I. That's why I didn't know why you would say that it was an abuse.
Well, let's talk about that.
I mean, the bottom line is, what is abuse mean?
That's correct. And my position is that in a case like this, where you have one scenario...
But we've had all kinds of cases where we have one scenario and another scenario. And we've never said any place that the court has to give special interrogatories.
Well, that's my position, that the court does in a case like
and
this.
You can't cite any case,
well,
but you're just arguing it. Let me ask you this. Let me change it just a little bit. Did you preserve this?
Yes.
What about filing a 50A motion? Did you file one?
No.
File a 50B motion?
No.
Well, then how do you preserve qualified immunity?
Well,
given Tort 2 versus Las Vegas.
Given Tort 2, first of all, Tort 2 was a somewhat complicated case.
Well, I was there. I know how complicated it was.
Okay.
But the district court never ruled on the immunity defense, and therefore we said, having not filed those motions, the district court should be affirmed.
Well, let me tell you the difference. First of all, filing a Rule 50A motion in a situation where there are material disputed facts would not have accomplished anything.
Well, just a minute. The bottom line is that you file a motion to begin with, you can check qualified immunity up front. You don't have any way really to win on qualified immunity here up front, because we're going to take the plaintiff's facts.
Correct.
So then you come to the 50A motion, it kind of leads in the same result.
Correct.
But once to get to the 50B motion, which is the reason you would even do it. In order to preserve it, you've got to file a 50B motion. At that point, the court may be convinced.
You would still, in a 50B motion, be...
You don't, at 50B, you would have the chance for the court to think about the case anew.
Not with respect to the officer's facts.
So what you're saying is our idea in tort 2 is wrong. You don't have to file a 50B motion.
If that's what you say tort 2 stands for, then I would say correct, it's wrong, because you cannot resolve this issue on a 50A or a 50B motion. And so in this context, what I did was ask for interrogatories to then allow a 50A or a 50B or both, 50A at the trial, on the facts that a jury would have found and say, aha, Your Honor, we have facts now.
Yeah, but just a minute. It seems to me that if you're really going to look at this under the second prong of the test,
well,
what the jury finds as to facts is going to have some help, but you may be able to determine this yourself as the district court. Why not make the 50B motion?
It would have been futile, Your Honor.
Okay. I understand your question.
It certainly would have been futile. Tort 2 did not involve what we're dealing with here, which was the question of whether to give interrogatories. The only way I had to challenge the court's decision not to do that was a motion for new trial. There was no other way to challenge that, Your Honor.
All right.
Okay.
Now, let me ask this question as an outsider here.
Yes, Judge.
Okay. And I'm bound by what the Ninth Circuit has said. Has the Ninth Circuit ever said that under a case like this, that you have to file a 50A or 50B motion, or you're precluded from asking for interrogatories?
Plaintiff interprets Tort 2, and I think the AD case interprets Tort 2 to say that. I disagree in this context. In this context, I asked the court to do something which I feel under the case law is required. And if I may step back and just talk about that for a moment, there are, at least there are dozens of cases which say, how do we deal at trial with this dilemma?
And there are other circuits that have said this is what you should do.
Absolutely.
Or this is what is done. But has the Supreme Court ever said that you must submit interrogatories in a situation like this?
According to Schwartz, who wrote the treatise on this, the Supreme Court has not ruled on this issue at all. It has engendered confusion among the circuits, and it hasn't been determined yet. I will say that in looking at the Ninth Circuit law, the trilogy of cases which tangentially addressed this issue, they all said it's not an abuse of discretion, but they had a reason for it, because it made no difference, because the facts that once the jury made its determination, you didn't need to know what the facts were, because you could determine from that jury determination that qualified immunity doesn't apply. This case is not like that.
Was the jury instructed on qualified immunity?
No. And
Did you ask for the jury to be instructed on qualified immunity?
Of course not, Your Honor. I believe, and the case law, although it may be somewhat, back and forth, muddied, the prevailing view is, no, of course that issue doesn't go to a jury. How could a jury decide what the law is? Right. Or what the established law is? So no.
So your argument is the jury couldn't do that, but the jury's role is to determine what the facts are.
Correct. And I think this is all supported by last month's case from the Ninth Circuit, the San Diego case. In that San Diego case, which was a summary judgment case, the court looked at the facts. It was a guy kneeling with two knives in his pockets, and there was some dispute among the officers about whether he had actually pulled the knives out. And the court said, look, Under those facts, most favorable to plaintiff, a jury could find a Fourth Amendment violation. They might find that this wasn't a threat. They might find that the officer didn't, he couldn't see where the other officers were. So, I'm not going to grant your motion for summary judgment on that. However, and this is the important thing, even in a situation where the facts could be interpreted to show a violation of the Fourth Amendment, the court, of course, has to go further. And, we've been having qualified immunity cases over and over, and the Supreme Court keeps telling the Ninth Circuit to look with more specificity than they do, and they call it
Don't cite that to us.
Okay. You know the
what
case.
you're saying.
The bottom line of that case is that there's no case law that would explain that the actions, that you have to wait for the guy to pull out the knife. The case law, in fact, the consensus of case law is that when he reaches for the knife, you can use excessive, you can use deadly force. So the point is, this case is very similar to that in that the officer's scenario is subject to dispute in terms of whether a Fourth Amendment violation took place. Could the officer have done something different? Was there an alternative? Could the officer have run away? Was the guy coming at her fast enough to cause her to have a fear? And even with that, qualified immunity applies. And I'm sorry to interrupt, we've never gotten this officer the ability to have it litigated about whether she's entitled to qualified immunity.
My question is, and I'm sorry to interrupt.
No,
I'm saying, I thought there was a pause in what you were saying. I was trying to get in there. But when did you last preserve this? What stage in the proceeding was it in which you asked for the special interrogatories?
At the jury charging conference.
All right. If in fact I was the trial judge and I said, okay, I agree with you, how would this work? How would this work? Would I give the entire charge to the jury in this case and say, before you move to the question of liability or damages, you need to come back and answer this question on qualified immunity? Or would I submit that question immediately and say, ladies and gentlemen of the jury, we're not at the point where you're going to decide this case. We're at the point where you're going to decide some factual issues, which we think is important for this case going forward.
I'm not sure of the answer to that.
Okay.
I'm not sure if it would happen after the instructions or before you even get to those.
But I think all of that goes into our determination as to whether or not the district court abused its discretion in doing something that appears even under Rule 49, and that's where this comes from. Rule 49 of the Rules of Civil Procedure, correct?
Mm-hmm.
Right.
And they don't even call it special interrogatories, they call it special verdicts.
And it may have been a verdict.
It's something so unusual, I guess it might be the right way to do it, but how do you say it's an abuse of discretion?
I say it's an abuse of discretion because otherwise the officer loses her right to a litigation of her entitlement to qualified immunity on real facts, on really what happened.
I mean, I understand your argument, but that's why I hit you so hard on 50A and 50B. You suggested it make no difference, but there are a lot of objections counsel makes during trial to preserve the objection on appeal, to preserve the right to bring the arguments you're about to make on appeal, and you make the objections even when you're going to lose. And no objection was made here.
Yes,
and there was no 50A motion, there was no 50B motion, and it seems to me, based on our precedent, if one had wanted to preserve what argument you're making, one would have made those motions.
Only if those motions were made after the jury made a factual determination. Those motions, either one of them or both of them, were completely futile.
Well,
I understand what you're saying.
I hear what you're saying about futility, but I know what I've done on any number of occasions standing in your same place. having the district court said, you're not letting that evidence, I'm not letting that evidence in, and I made futile objections nonetheless because I wanted to preserve for appeal. And if I'd looked at Tortu, I don't know how I could have, in this case, not made a 50A and B if I wanted to preserve my right to argue what you're arguing.
Because the 50A and 50B could only be heard after the facts were determined. They could only, the only way to deal with this issue was through interrogatories.
50A and 50B are not given to the jury.
No.
50A is given to the judge.
Clearly.
And the judge can make that determination, but you didn't even ask.
But if I asked the judge,
All right, we've argued enough about that.
Okay,
Yes.
thank you.
Thank you.
Thank you. Good morning. Ben Nissenbaum for the plaintiff and Ayana Curry. May it please the court, I think the court obviously has hit on maybe the threshold issue in this case. That is qualified immunity preserved at all? No 50A motion was made, no 50B motion was made. That's the end of the story with respect to qualified immunity. This is a case where the defense counsel is required under the Ninth Circuit precedent to make those motions, and you make the effort, even if you know that you won't win it. You still make the effort to preserve the record for appeal. That's what you do. In the same way, by the same token, if the special interrogatories are that critical, it seems to me that it is also incumbent upon the lawyer to make the effort to persuade the judge by submitting some examples of the special interrogatories that you would want to have answered. That's never happened. We haven't even had an example of what one of those special interrogatories might look like. And it hasn't happened.
Well, the problem that I have with this case, I will just lay out for you.
Sure.
It seems to me like the jury's verdict disagrees with itself on two issues. If I had had qualified immunity in front of me, if counsel should have raised it or could have raised it, I may say, based on the case law, given that there was no battery, that in fact the second prong of the analysis cannot be met. So what do I do with this?
The first point is that the qualified immunity issue is not legitimately before the court. It has been waived, it has not been preserved. So you don't get there. But I would actually take issue with that, because what I would do is I would look at the jury instructions between the Ninth Circuit jury instruction and the California state law battery instruction. I'd put them side by side, and I'd look at it to see, is there a conflict, not in the law, because the jury doesn't get the law, the treatises that say that these are the same. What the jury gets are the actual instructions. And those instructions are actually different. And so it may be that everyone believes that they are the same, but in reality, the instructions are different.
It isn't a matter of whether they believe. I got no precedent suggesting they are really any different.
But you can read the jury instructions, and you can point to the differences in the jury instructions, particularly.
How could this jury verdict not differentiate with its own verdict, given the verdicts given? Give me a scenario.
Absolutely.
And therefore, the second prong is well satisfied.
So looking at the Ninth Circuit instruction, the availability of less intrusive alternatives. One of those is simply redeploying your location. Now, we set out a scenario of scenario A and scenario B. And obviously, scenario A is where Officer West is at the bush, stuck in the bush as she described, totally inconsistent with the shell casing evidence. Their own expert agrees with that. Our expert says virtually impossible. Their expert says highly unlikely. But the scenario B is where the shell casing evidence actually places her. And of course, that's evidence. The evidence places her at scenario B. And what you can find there, when you cement her feet in place, as the California jury instruction does, that effectively does what she says she did when she stepped in the bush. She couldn't move. And so when a person is closer to a man with a knife who is disturbed, there's obviously a potentially greater danger based on the officer's mistake that he was dangerous. And so I think that alone accounts for the difference. The jury instruction says retreat is not an option. I know defense counsel made reference to the jury instruction not saying in the course of effecting an arrest. Well, I don't think that's material here. She has her gun drawn on him. That's obviously what she's intending to do. But it says it takes away that option of redeploying. Defense counsel cited to law saying that redeployment or retreat is not an option under federal law either. Law doesn't say that in any way. Law says under those circumstances, which are a person who is in a drainage ditch, officers in a drainage ditch with a man who's lifting a rock over his head coming at them, a man who's there next to the freeway, a man who's been driving in a very dangerous way and can go into traffic. It says under those circumstances, retreat was not a reasonable option. Well, in this case, there's no freeway, there's no real traffic. He's in his neighborhood, he's in his yard, and he hasn't been dangerous to anyone. And that's obvious. We have that from Mrs. Anderson's testimony. So retreat in this case is appropriate. Our police practice expert testified to that, and you can call it redeployment, you can call it retreat, but there is no case law that says that you should not redeploy, and the availability of less intrusive alternatives is a critical issue here.
Okay. Let me ask you about the Tortu case. Is this case in a little different posture than Tortu?
It's in a different posture because our judge denied the Rule 59 motion. Our judge didn't overturn the verdict, so it is in a different posture. And I think the dissent...
But prior to that, I mean, they filed a Rule 59 motion for a new trial. And they're saying one of the reasons that we should be given a new trial is the court abuses discretion in not submitting special interrogatories to the jury. Doesn't this put this in slightly different posture than Tortu?
I think it does. In that case, well, with respect to the issue of special interrogatories, I think what Tortu is, well, the answer is yes. In this case, the court declined special interrogatories, and if you go to the point of special interrogatories, it is to explain issues in jury instructions that may not be clear. If the jury instructions are clear, and the Ninth Circuit instruction is very clear, standard instruction, then you certainly don't need special interrogatories. With respect to Tortu, going to the special instructions there, I think the key point is the court found that the jury, there were different uses of force in that case, and so in terms of what could have constituted the excessive force was at issue.
I guess my point is, as the Ninth Circuit specifically said, that the only way to address the question of qualified immunity in a case like this is to file a Rule 50A and 50B motion.
Yes, absolutely. Tortu says that. And cases have held beyond that is the case. The reason being is that for the first prong is the fact question. The jury finds the fact of the constitutional violation. The second prong is the legal question. Was it clearly established that the officer had violated the Constitution? And on that point, that's why you make the motion. That's why you make the motion. It is a legal determination. You're asking for motion for judgment as a matter of law, and you're renewing that motion at the end of the case. I mean, there's no question about it. Frankly, it's standard. It wasn't done in this case. And the other point I want to make to that, the special interrogatory issue is really a subsidiary component of the qualified immunity argument. So if qualified immunity is not at issue, neither are these special interrogatories. So provided that it is waived.
I didn't quite understand that. Say that again.
Provided that the qualified immunity argument is waived, then the special interrogatory argument is likewise gone, because it is a subsidiary component. It's only relevant to that point.
Let's suppose here that the city had filed a 50A motion.
Okay.
At the appropriate time. Okay?
Sure.
Could the court have even ruled on the 50A motion since the factual determination had not been decided?
The court could have ruled, it could have taken it under advisement.
To do what? To do what?
To subject it to a Rule 50B motion after the case, and then to preserve the matter for appeal, to preserve the issue for appeal. And as indicated, you make all kinds of objections knowing you will lose them in order to preserve the matter. It's just a matter of fundamental practice. Now, another point in Tor 2, obviously from reading the court's dissent in that case, the denial of the Rule 59 is sound. It is not subject, really, in this case, to being overturned at all or questioned. The trial court had the opportunity to assess and evaluate the credibility of the witnesses. The trial court was able to see the color that Officer Phelan turned when he was impeached as badly as he was. The trial court recognized what happened when Officer West, likewise, was badly impeached. One of the issues here, and I argued with respect to the defendant's arguments on the closing argument point, I argued countless times, and I actually listed it out. I could cite to you the locations where I pointed out the difference between the negligence law and the Fourth Amendment claim. We are not claiming provocation here. This is not Mendez at all. This is not a case where the jury could have been confused that the preceding tactics were the basis for the violation. We explicitly argued it otherwise. You can look at serial excerpt of record 1460 through 69, 1480 through 82, 1487 through 89. You can look at 1464 through 65. It's there throughout. What I did say, though, is that the jury could use the statements regarding the preceding conduct to assess the officer's credibility with respect to her claim that she was stuck at the bush. I did say that, and that is true, because if she was dishonest about those prior statements, then certainly that could be used to assess her credibility about being stuck at the bush. The shell casings didn't support it. Both experts agreed that story was highly unlikely. Officer Phelan at trial put her at the bush, but earlier in his post-shooting interview, he put her so far away from the bush when she fired that he didn't even remember the tree being there, and the bush is right around the tree. And this was, frankly, a very strong verdict in my view. And I think the battery is a function of the actual wording of the jury instructions themselves. That seems clear to me. Now, another point. The defendants have tried to analogize Rule 51 to Rule 50. That is obviously inappropriate. Rule 50 has strict guidelines, strict requirements. Rule 51, and if you look at Franklin, that was a dispute over jury instructions governed by Rule 51. This is not that. This is a question, at what point in time do you forfeit your Rule 50? At what point in time does that happen? You should have it filed by the close of evidence, but certainly, the only exception here is that it can be some added time up to the point in time when the jury gets the case. But if it's not filed by then, you've lost it. You can't file it. That's what happened in this case. For all the excuses that they make, there are 2 points. They never filed and they never gave an actual example of the special interrogatories, and they never actually followed through and did a Rule 50. So there's no follow through on either of those. So I'd submit to you that this is more of a after the fact, after the jury verdict, trying to find a way out of it.
Hindsight? Is that?
Correct. And I hate to say that with respect to the Ninth Circuit with the Graham v. Connor standard, but exactly.
Is there an argument to be made here that the jury actually found against the question of qualified immunity when they found the Fourth Amendment violation?
I think so, because I think that the issue is that I told the jury that if she's at the bush and he's coming at her with a knife, as she claimed, we lose the Fourth Amendment claim and we only have negligence liability then. But we lose the Fourth Amendment claim. But if it is scenario B, where she's not stuck at the bush, where she herself has run up on him and shot him, which is, and this is analogous to Glenn in some respects, but it is also just a basic excessive force case at that point. If that is the case, then we win. We win the Fourth Amendment claim. And if you go through my closing argument, perhaps my fault, I never actually addressed the state law battery instruction. Maybe if I had, we would have had a different result. I don't know the answer to that. But the judge looked at all this in his Rule 59, and he was exposed to all of it, and being the person in closest proximity to the issues, found that there was no reason to overturn the verdict. One last point I want to make. What is the standard of review? Is it de novo or abuse of discretion? The qualified immunity points really go to issues of fact, and the court is in the closest proximity to the issues of fact. That's why the special interrogatories and whether to give them are subject to abuse of discretion standard, because they're factual to the case. Thank you.
Thank you. You bet. You have a minute.
I come back to the issue that haunted us in this trial, and that is how to deal with this factual dispute. I think the district courts deserve an explanation of how to do it. The officer deserves an explanation, and in fact, the officer really deserves an evaluation of her conduct as determined by the jury, evaluated by the judge to determine whether qualified immunity could be applied. And that is what she lost in this case. And that's a legal issue. I don't believe Tortu applies to this. I believe it's distinguishable. And one question that the court asked about the battery verdict, if there is no battery, the jury could not have found that there was no threat. If there was no threat, if whatever happened in this scenario did not result in a threat to the officer, you would have to have a battery. You would have to. You cannot shoot someone for no threat. They are inconsistent. When I understand that the court has a different way of looking at inconsistent verdicts, but when they're general, but that's not what I'm talking about. What I'm talking about is how do you evaluate the facts that the jury found when you had those two verdicts? And the only way to do that, the only way to even come close to getting those verdicts consistent is to believe that the jury found that the man was a threat. He was a threat, but that the officer should have done something else. And that brings us right into qualified immunity, because there's no case law that says a scenario like this where the man is a threat to the officer, she doesn't have the right to use deadly force.
We understand your argument.
Thank you, Your Honor.
Thank you very much. Case 1616052, Lamb versus San Jose is submitted.